afternoon, everyone, and thanks for joining us. I'm Karen Chalmers, the Senior Director of Brand and Engagement here at Tech Alliance. As the Regional Innovation Center for Southwestern Ontario, Tech Alliance empowers world-class ventures and fuels growth in Canada's innovation economy. We champion and coach entrepreneurs, amplify and impact businesses, and contribute to a bold technology community across the region. If you'd like to engage with our venture growth team, read stories about innovation that is shaping our community with world-changing ideas, or join other upcoming experiences, I invite you to subscribe to our newsletter using the link in the chat. We are the place for dreamers, innovators, and world-changing ideas. In the pursuit of creating spaces where innovation thrives, we must act, be bold, and lift others as we rise. And we strive to do that in all that we do. To put it simply, we support entrepreneurs and ventures at every step of the entrepreneurial journey. Before we get started today, here's a few housekeeping points. All participants' mics are muted, so relax and enjoy. Today's webinar will be recorded and available for replay on our YouTube channel. And I encourage you to add any questions for our guests in the Q&A feature at the bottom of your screen, and add any comments in our active chat feature. So now, let's focus on what's quickly becoming a new norm: hybrid workplaces. Hybrid workplaces require adapting and transforming as a new standard for business. They bring increased flexibility and help empower company culture to add efficiencies. Yet, with these dynamic and broad sweeping changes and employee expectations, heightened awareness and consideration of the associated risk factors are a must. Today, we're joined by Cristina Borbely and Shefali Rajaputra of Gowling WLG Employment, Labor and Equalities Group, an international law firm which consists of independent and autonomous entities providing services around the world. As employment and workplace experts, they will bring insights into what needs to be considered as restrictions lessen when transitioning from work at home to work with whatever your company's plans are in the near future. Be prepared when providing employees a choice by staying informed on health and safety laws and employment standards. Before we get started, here's a bit about today's speakers. Cristina Borbely is an associate in Gowling's Employment, Labor and Equalities Group. In her role, she advises employers on a variety of workplace matters. Cristina graduated from the Peter A. Allard School of Law at the University of British Columbia. Shefali Rajaputra is an associate lawyer in Gowling's Employment, Labor and Equalities Group, with a practice focusing on employment law. Shefali grew up in India, where she attended law school and began her career as an employment lawyer at a full-service top-tier law firm. She subsequently moved to Ontario with her spouse and joined Gowling. If you find after today's webcast the time you spent with Shefali and Cristina just wasn't enough, you can double down tomorrow by booking a one-on-one virtual office hour session with Sean Gomes, a partner practicing business and technology law for Gowling. Sean would be happy to connect with you to answer your questions specific to your business. The link to book your personal time slot with him will be dropped in the chat. So without further ado, Shefali and Cristina, I'll pass this amazing session over to you.
Thank you, Karen. Good afternoon, everybody, and thank you for joining us today. I would like to thank Tech Alliance for organizing this event. In the next hour, we're going to cover a range of topics relating to hybrid workplaces. Here is our agenda for today. Bear with me with the slides. There we go. So first, I will provide an overview of considerations for remote work that employers must bear in mind. Second, Shefali will give an overview of considerations for hybrid workplaces, as well as best practices for hybrid workplaces. Finally, I will provide a brief overview of cybersecurity and privacy breach risks facing employers, as well as a brief summary of privacy legislation that employers should be aware of. We will also have a Q&A at the end of our presentation today. So on to our first topic, remote work considerations. So most of us have been working from home for over a year now, and this has dramatically changed the landscape of work and the workplace environment, with the future of work likely to include agile and flexible working arrangements where workers work from home for at least a portion of the work week. In dealing with a remote workforce, employers should consider the following: occupational health and safety laws, compliance with employment standards legislation, and employees working remotely in different jurisdictions. For the purposes of today's session, we're going to focus on occupational health and safety laws, but we will also briefly touch on compliance with employment standards legislation and jurisdictional issues. So under the Ontario Occupational Health and Safety Act, employers have a general duty to take every precaution reasonable in the circumstances for the protection of a worker. Employees also have a general duty to comply with the Occupational Health and Safety Act and to report to their employer or supervisor any hazards of which they are aware. The Act does not have any rules surrounding remote work. The Act does define workplace as any land, premises, location, or thing at, upon, in, or near which a worker works. However, Section 3(1) of the Act provides that it does not apply to work performed by the owner or occupant or servant of the owner or occupant to, in, or about a private residence or the lands and appurtenances used in connection therewith. So it is unclear if the Act is applicable to workers working remotely from home. While direction from decision makers is sparse, two decisions offer contradictory direction with respect to the application of the Act to people working from home. In a 2013 decision, Watkins and the Health and Safety Association for Government Services, the Ontario Labour Relations Board considered allegations of workplace harassment and reprisal made by an employee who worked remotely from his residence, but also traveled as part of his duties. This case proceeded to a hearing, but no arguments were made with respect to whether the Occupational Health and Safety Act applied to workers from home. So this case does not offer much guidance. Alternatively, in a 2016 decision number 2249/16, the Ontario Workplace Safety and Insurance Appeals Tribunal considered whether the Occupational Health and Safety Act applied to work performed by an owner in a private residence. The employee had been offered modified work at home, reviewing health and safety materials. The tribunal in this case expressly stated that the Occupational Health and Safety Act does not apply to work performed by an owner in a private residence. Despite this decision of the Workplace Safety and Insurance Appeals Tribunal, the best practice is to assume that the Occupational Health and Safety Act does apply to workers while they are working from home. The Canadian Centre for Occupational Health and Safety, or the CCOHS, was established in 1978 under the Canadian Centre for Occupational Health and Safety Act, with the aim to promote the well-being of workers in Canada. This provides guidance for best practices for employers, and they recommend that policies and/or agreements should be implemented to ensure that employers and employees are aware of responsibilities and expectations for remote work. Employers should therefore review their remote work policies, or where such policies are not already in place, implement written remote work policies. These policies should set out specific rules and procedures regarding work from home arrangements, the acceptable use of company technology, as well as expectations for privacy and confidentiality in a remote environment. So remote work policies will vary depending on the type of work, the number of employees, and the business of the employer. Generally, however, in creating a remote work policy, employers should bear the following in mind. Will employees be able to work from home upon request, or only when mandated by public health and safety requirements? What processes are in place for employees who cannot work in the office full-time due to protected grounds under the Human Rights Code, such as disability, family status, or marital status? Is remote working a term and condition of employment, or can it be revoked unilaterally by the employer at any time? What hours will the workers be expected to keep when working from home? How will their performance be assessed remotely, and how will overtime be approved? Will workers be able to take equipment out of the office for their use at home, and what processes will be in place? Will the worker be reimbursed for any costs associated with working from home? What happens if a worker decides to relocate outside of the province? Workers should also be made aware that they have a responsibility to ensure that their workspace at home is free of hazards. As well, will the employer inspect a worker's home office? If so, how often? The Occupational Health and Safety Act provides that a health and safety representative inspect the physical condition of the workplace at least once a month. Where there are hundreds, if not thousands, of employees working from home, this is not necessarily practical. However, if the Act applies to home offices, then situations may arise where this may be mandated or recommended. So how will a worker notify the employer of accidents that may occur in a remote workspace? And who is responsible for damages caused by accidents in the workplace? Who pays for insurance? Who pays for equipment used by the worker, including internet, hydro, insurance, etc. In addition, the policy should set out clear procedures and expectations for how to deal with confidential information, including the removal of physical records from the workspace. For example, must employees sign out physical records? Are employees allowed to remove physical records from the workplace at all? Next, how are employees expected to protect confidential information from access and view by unauthorized people? Finally, the remote work policy should set out guidelines for establishing and maintaining secure network connections to protect from cyber attacks. So the exact content of the remote work policy will differ by organization, but these are just a few of the considerations that organizations should keep in mind when reviewing and implementing their remote work policies. I will now turn it over to Shefali to discuss employment standards considerations.
Thank you, Cristina. Now that you're all aware of your obligations under Occupational Health and Safety Act based on the information provided by Cristina, I will be spending a few minutes talking to you about another consideration for remote work setting, which is the employment standards legislation. So, as you may already know, the Employment Standards Act is the primary legislation for provincially regulated employers, which governs the terms and conditions of employment. The Employment Standards Act imposes certain obligations on employers with respect to employees and their relationship as an employer and employee. Some of the obligations, as you can see on the slide here, are with respect to tracking hours of work, vacation time, vacation pay paid to the employees, tracking overtime, maintaining various records for different periods of time pertaining to the aspects that I just mentioned, and some additional aspects such as details pertaining to leaves of absences. Practically speaking, these obligations were more easy to comply with when the employees physically attended the workplace. However, with COVID-19 and the employers permitting remote work overnight for employees, oftentimes these obligations are unfortunately ignored. Remember, the Employment Standards Act has not been amended to make an exception due to the pandemic. What that means is that these obligations under the employment standards continue to apply to the employers. So what do you need to do to ensure that you still comply with your obligations under the employment standards, even in a remote or a hybrid setup? First off, managers should have schedules and track the hours worked by the employees. There are softwares that help employers track the number of hours in vacation, etc. These softwares have been existing for a while now, but they've only gotten more popular now because of the work from home setup. Next, employers can consider putting in place, well, they must put in place overtime policies, which managers should strictly enforce. The overtime policies, although not mandated by law, will help you regulate the overtime practices of the business. And they will also help you ensure that you're tracking the number of hours that the employees are working. The information which is tracked will be helpful in maintaining the records which the employer is required to do as per the employment standards. And remember, these records will need to be produced to a Ministry of Labor inspector if he or she comes knocking on the door, either on their own accord, which they can do, or because an employee has filed a claim with the Ministry of Labor. So these are the things that you need to keep in mind with respect to obligations in the ESA, tracking and record maintenance. Moving on. Now, on this slide, you will see a poll question that I'd like you all to participate in and provide a response to. To give you some context, this question has been one of the most asked questions by our clients in the last year and a half since the pandemic hit. Can I please have the poll question on, please? And I'll read it out. Okay, so the question is, Angela works for a company XYZ, which is based out of Toronto. Angela lived in Toronto at the start of her employment, but in 2018, but relocated to Banff, Alberta during the pandemic and has no plans of returning to Toronto. Angela's duties can be performed 100% remotely. And the question remains, the company is wondering which province's employment standards apply to Angela. We'll wait for a minute or so that all our audience can put in their responses, and then we'll go from there. Okay, so let's look at the responses here. So we've got a mixed bag of views. So we've got 68% of our audience who think that the Ontario Employment Standards Act applies. And then we've got about 32% of the audience who thinks that the Alberta Employment Standards Act applies. Now, all of you who selected Alberta Employment Standards Act, give yourself a pat on your back, because that is the right answer. Now, the legal basis for this one is that the law of the province where the employee resides governs. I know it's an eye-opener for a lot of businesses, but this is a big consideration that you need to keep in mind before you let employees go and work in different provinces, especially Quebec, because you know that Quebec has its own civil code and it has its own different set of legal rules and principles, which are very different from common law jurisdictions. So what this essentially means is that in this example, Angela will now be governed by the Alberta Employment Standards Act with respect to the aspects such as overtime, vacation, leaves of absences, and finally, and most importantly, the termination provisions. Yes, that is the big one. So therefore, it is very important for you to know where your employees are and ensure that their employment agreements are updated from time to time to reflect the governing law within the employment agreement. Oftentimes, this becomes a big issue at the time of termination, as the executed agreement will be drafted as per the Ontario Employment Standards Act, but the applicable one now is the Alberta Employment Standards Act. So depending on the cases within the province and the jurisdiction where the employee has relocated to, there could be circumstances under which that employment agreement no longer applies. And in that case, you're now looking at an employee who's entitled to common law damages, which is which are significantly higher than the statutory entitlements that are provided to the employees. So this is very important, and you need to keep in mind. I know with the remote work settings, a lot of employers have permitted their employees to continue working in different provinces for a number of reasons, including family considerations and whatnot. But when you permitted these employees to work from these provinces, you can certainly enter into employment agreements for consideration, of course, and make sure that these employment agreements are now up to date and are based on the provinces, based on the province where the employee resides. Next, moving on, there are some other implications that the employers need to keep in mind when approving remote work arrangements. The first one, of course, is the employment standards, which we just covered. Following next to it is the human rights and the pay equity legislations. Pay equity legislations in general in Ontario and the province of Quebec there are private sector pay equity legislation which apply to private employers as long as you have 10 or more employees. But in the other provinces, it only applies to public employers. With respect to human rights, what you need to keep in mind is that, well, the basic principles pretty much remain the same from province to province, but they might be different prohibited grounds of discrimination that may be different from province to province. To give you an example, citizenship is a prohibited ground in Ontario, but it isn't a prohibited ground in British Columbia. So if you have an employee who used to work in BC and now has relocated to Ontario during the pandemic and has been living in Ontario for the last year and a half, now this employee has rights that are coming into the Ontario Human Rights Code with respect to protections for citizenship. So that's an example. Another example is the applicable employment standards and human rights statutes in British Columbia, Ontario, and Quebec do not offer protections to otherwise healthy individuals simply because they're not comfortable commuting to and from work on public transit. But on the flip side, Nova Scotia is an outlier, offering employees protection from discrimination if they have irrational fears associated with infectious diseases, including COVID-19. So we would expect a stated discomfort regarding the safety of travel on public transit would qualify as an irrational fear of contacting an infectious disease, and accordingly, disciplining or termination on this basis is likely to be contrary to the Nova Scotia human rights legislation. So that these are nuances that employers and businesses need to keep in mind when it comes to other jurisdictional laws being applicable when the employee relocates. Next is the health and safety legislation. So the health and safety legislation is provincially regulated, and each province pretty much has its own set of occupational health and safety rules and regulations. When permitting employers to relocate to other provinces for remote work, you need to start thinking about applicability of workman's safety and insurance legislations and obligations under those legislations. For example, in British Columbia, even if you have a single employee working from home, you must register with WorkSafe BC. That is something different from what you would have to do in Ontario because there is no such requirement in Ontario. So those are some of the considerations that you need to keep in mind in addition to the Employment Standards Act when you have workers who relocated or are relocating during the pandemic to different provinces. So moving on to our next topic of the day, hybrid workplaces. What are hybrid workplaces? A hybrid workplace is a business model combining remote work with office work. Now, the question, $1 million question that everybody has these days is, are hybrid workplaces the future? Is that how our workplaces are going to be defined going forward? And the answer is, it could be, and it depends. Let's look at some stats when it comes to this question. According to Microsoft's 2021 report, 73% of employees surveyed expressed a desire for flexible remote work options post-pandemic. And 66% of businesses said they were considering redesigning physical spaces to better accommodate hybrid work environments. Now, some of the big names, let's look at Twitter, Facebook, and Google. What are they doing? So Twitter made global headlines when it announced that its employees could work from home forever if they wished. I know, I wish we were all working there, don't we? Facebook followed suit the same month, with the CEO Mark Zuckerberg noting up to 50% of the company's workforce could be working remotely in the next 5 to 10 years. And lastly, Google is currently allowing its employees to work remotely until September 2021, with plans to test a flexible work week once employees return to the office. So with big companies such as Twitter, Facebook, and Google setting the trend, it won't be long before a lot of other employers start implementing a hybrid workplace model going forward. This is because one thing we have learned coming out of this pandemic is that people can work efficiently from home and work can be managed remotely. Of course, there are always exceptions, but that is pretty much what every employer and employee have learned. With this background, let's now look at why are we talking about hybrid workplaces today and not 3 or 4 months ago. So as of July 16, 2021, Ontario entered into step 3 of its roadmap to reopen, which allows for expanded access to indoor settings and the relaxing of rules in respect of certain establishments. Unlike the restrictions under step 1 and step 2, step 3 does not contain the explicit work from home except where necessary requirement. As a quick reminder, step 1 and 2 regulations stated that every person responsible for a business or organization that is open shall ensure that any person who performs work for the business or organization conducts their work remotely unless the nature of their work requires them to be on site at the workplace. What it essentially meant was for businesses that were open during the pandemic or under step 1 and step 2, they could permit only those employees with the roles which required to be in the office. Say, for example, a receptionist in a construction company who's not only responsible for answering phone calls, but also responsible for collecting checks and cash with respect to construction projects and couriers that come into the office. But with step 3, this requirement no longer exists. What it means is that employers have more flexibility to bring back their employees to the workplace, which is why we're now talking about hybrid workplaces. But with that in mind, we should also, what is interesting is that while step 3 likely signals that the requirement to work from home has been relaxed, employers should nevertheless continue to exercise caution in recalling workers to physical workplace 100%. This is because the province continues to recommend in its guidance that all workers who can work from home should continue to do so. Under step 3 of the reopen plan, office workplaces that are not accessible to the public, meaning where it is possible to segregate employees from public and establish employee-only access, can reopen with no capacity restrictions. That said, every employer is at liberty to impose capacity restrictions as they see fit. Under step 3, the rules also require all members of the public in an indoor space of business or facility that is open to the public to maintain a physical distance of at least 2 meters from every other person. At workplaces, workers must be separated by 2 meters or a physical barrier when their face mask is temporarily removed. Well, that said, the rules under step 3 also impose a broad duty on businesses to operate in accordance with applicable laws, including the Occupational Health and Safety Act and the regulations made under it. Now, let's take a closer look on what these health and safety protocols look like under step 3. On this slide, you'll see the health and safety protocols that businesses need to keep in mind going forward, especially if you're contemplating a hybrid workplace. First and foremost, you need to have a COVID-19 workplace safety plan. We will deal with this a bit more in detail shortly. First, let's talk about the remainder of the protocols. First off is the screening. Employees must be actively screened either before or at the time they arrive at the workplace for each shift. This requirement has been there in this step 1 and step 2, and it continues to be there. Screening must be done using the questions contained with the province's COVID-19 worker and employee screening tool. Employers and businesses need to keep in mind that this screening tool, which is shared by the province, is ever evolving and ever changing. So you need to make sure that you are using the most up-to-date screening tool. Well, I said actively screening. So what does active mean? Active means that someone needs to verify that individuals entering the workplace are screened. And this can be done whether in person, electronically, or even using an app. So you can't just have a printed off a sheet right at the entrance of the workplace which says that employees will do a self-screening, just check off all the boxes and just enter. You also need to make sure that those responses are being verified. Doesn't necessarily need to be physically verified by another person, and then letting these employees come in. Posting signage that says do not enter if you have these symptoms is generally recommended, but it will not in and of itself meet the active screening requirement. You still need another person to verify the screening tool. Mandatory face coverings. Employees must comply with the applicable mandatory face covering requirements. Where maintaining 2 meters or 6 feet physical distance is challenging at the office, workplace, employees need to wear compliant masks and eye protection. Typically in these circumstances, cloth masks are not compliant. Think about medical grade or surgical masks, which will meet the standards. Eye protection can take the form of face shields, spectacle whipping, certified glasses, or certified safety goggles. During lunch breaks, employees are permitted to remove their masks and eat indoors, provided that they are separated by a distance of at least 2 meters or 6 feet, or a plexiglass or some other impermeable barrier. With respect to physical distancing, generally speaking, physical distancing of 2 meters or 6 feet needs to be in place. This is not something that is new. This has been in place, and this continues to be the case under step 3. With respect to enhanced sanitization, for certain office places, there may be sector-specific enhanced sanitization protocols that are set by workplace safety and prevention services. So if you're not sure whether your business or an office requires a different set of sanitization protocols, I would urge you and encourage you to check out the Workplace Safety and Prevention Services website, and that will have a list of different businesses that require a special set of cleaning or sanitization protocols. And lastly, signage. Each office workplace is required to post compliant signage that is relevant to its workplace setting in order to comply with the provincial rules and municipal bylaws. Let's now look a little bit more detail into the COVID-19 workplace safety plan. That was the first key factor that we needed to keep in mind for hybrid workplaces. So with respect to the safety plan, I would say that communication is key. And you as a business or an employer need to make sure that you're communicating the safety measures that you've put in place before you're able to confidently recall or call the employees back to the office, even in a hybrid model. And how do you do that? Is by implementing a safety plan, and also ensuring that the employees have been provided with a copy of the safety plan. Now, if it's not already in place, you should ensure that they have the COVID safety. You should ensure that you have the COVID-19 safety plans ready and available for review on request. Businesses and employers should also ensure that the safety plans are shared with employees for peace of mind, and to ensure that all are aware of expectations, responsibilities, and procedures. Employers must also assess the risk of transmission present in their workplace. I wanted to quickly talk about some key questions that your safety plan must include. First one is, how will you ensure that all workers know how they're able to keep themselves safe from exposure to COVID-19 in the workplace? The second one is, how will you screen for COVID-19? The third one is, how will you control the risk of transmission in the workplace? The fourth one is, how will you do it if there's a potential case? What will you do if there is a potential case or suspected exposure to COVID-19 at your workplace? Fifth, how will you manage any risks caused by changes to the way you operate your business? And finally, how will you make sure your plan is working? So if your workplace safety plan answers these 6 questions, then you are compliant with the requirements of the workplace safety plan as per the province's guidelines, and you're also providing responses or answers to the questions that typically employees have with respect to coming back to the workplace and the measures that are being implemented in the workplace. And it is important to know that the requirement to have a safety plan is actually a legal requirement that is coming out of the Reopening Ontario Act of 2020, and it's not just a recommended best practice. And generally speaking, the safety plan should describe the measures and procedures which have been implemented or will be implemented in the business to reduce the transmission of risk of COVID-19. Now, let's take a quick look at the occupational health and safety considerations in a hybrid workplace. So, as Cristina mentioned at the beginning of this presentation, Occupational Health and Safety Act requires employers to take every precaution reasonable in the circumstances for the protection of a worker. This extends to ensuring that all precautions reasonable have been taken to protect workers from exposure to COVID-19 in the workplace. Due to COVID-19, employers may be facing reluctance from workers to return to the office due to fears, such as contracting COVID-19 while commuting or in the workplace, or that other workers may not be vaccinated. So in certain circumstances, including the ones that I mentioned, employees do have rights to refuse unsafe work. But there is a procedure that is set out under the Occupational Health and Safety Act that needs to be followed by employers when an employee refuses unsafe work. If a worker refuses to attend the workplace and alleges that they do not feel safe in the workplace due to fears of COVID-19, employers are required by legislation to address their concerns. I wanted to quickly touch up on the process under the Occupational Health and Safety Act for resolving situations where workers refuse work. First and foremost is the employee must report their concerns to their supervisor or the manager or the management. Then the employee's supervisor or the management notifies the appropriate health and safety individual, to the extent that it is one, or the representative of the Joint Health and Safety Committee. Then the employer investigates in the presence of the employee and the worker safety representative. Then the employer should always document the complaint, the investigation, the decision, and the remedial steps taken to address the complaint of the employee. After these steps, if the issue is still not resolved and the employee continues to refuse to work, then the Ministry of Labor is involved. The Ministry of Labor investigates the complaint or the concern raised by the employee, and the inspector will decide if the circumstances leading to the work refusal are likely to endanger the employee or any other employee in the workplace. And finally, the inspector will provide their decision in writing. If the inspector finds that the circumstances are not likely to endanger anyone, the refusing employee is expected to return to work. Now, in our experience in the last year and a half, we had seen multiple refusals work and several instances where employers were forced to engage with the Ministry of Labor inspectors with respect to work refusal complaints that or concerns that were raised by employees. Our experience has been that to the extent that the employer has followed all the health and safety regulations and has put in place a health and safety plan and is taking active measures to ensure that safety is primarily taken care of and following the province's guidelines and Public Health Canada's guidelines, the inspectors have been pro-employers and have been providing decisions where where they feel that the fears are irrational, and they've been asking employees to return to the office. With that, let's look at the accommodation related aspects with a hybrid workplace. Now, coming out of the pandemic, businesses, employers must expect that there may be circumstances due to which some employees may not be able to return to work on a full-time basis or at all. This is when hybrid model comes in handy. Most common human rights code protected grounds include disability or illness, marital status, and family status. Example, employee living with a vulnerable person or employee who has childcare obligations. By having a hybrid workplace, you already won half the battle. You are already thinking about accommodation as you're obligated to under the Human Rights Code. What is important to remember with accommodation in a hybrid workplace is that the onus is generally on the employee to request accommodation. But if there are circumstances that suggest the employee may require accommodations, then the employer has a duty to inquire. Now, this is because under the Human Rights Code, duty to accommodate is a twofold concept, and there is procedural as well as substantive obligations that an employer is required to discharge. The procedural element requires that an employer must take steps to understand the employee's disability-related needs and individually investigate the potential accommodation measures to address those needs. Substantive element, on the other hand, relates to the reasonableness of the accommodation offered or the employer's reasons for not providing accommodation. Now, eventually the employer bears the onus on demonstrating that considerations, assessments, and steps were taken in accommodating the employee to the point of undue hardship. Lastly, employers must consider accommodation-related obligations while implementing flexible workstations and hot desks. I thought it's important to discuss a little bit about flexible workstations and hot desks, because that's probably one of the primary things that the employers and businesses must be thinking about when they are looking at implementing a hybrid workplace. For example, if you have an employee who has an accommodation plan in place or an accommodation implemented when they were in the office physically before the pandemic, which had, with respect to a sit-stand desk or an ergonomic chair, when you're implementing a flexible workstation or a hot desk, you must work with the employee, with the accommodated employee, to come up with a schedule when they attend the workplace, to ensure that they have the sit-stand desk available or accessible to them, or the ergonomic chair available to them when they are in the office. These are little things that you need to keep in mind with respect to flexible workstations. Just because you have a flexible workstation doesn't mean that your existing accommodation plans get tossed out. You just have to be creative and mindful about how best you can continue that accommodation and what measures can you take to ensure that that accommodation is provided in a smooth and consistent manner. In addition to this, for Ontario employers, there are also obligations under the Accessibility for Ontarians with Disabilities Act, which must be followed even in a remote hybrid workplace setup. Most importantly, obligation with respect to having a written accommodation plan is the most common and the most prominent obligation under the AODA. And this must be followed regardless of the fact whether the employee is seeking accommodation from home or from the office space. Now let's look at some best practices for implementing a hybrid workplace. So on this slide, you have a couple of pointers that you should be thinking about when you are implementing a hybrid workplace. We will delve into the updated workplace layouts and designs, addressing behavioral changes and updates to cleaning procedures a little bit more closely shortly. Let's discuss the scheduling in-person attendance first. So in today's world where health and safety is key, to ensure that you have a smooth hybrid workplace model, you need to think about scheduling in-person attendance. This will help with managing capacity limits in the workplace, and this will ensure that you're not overcrowding the workplace. Next, you also need to think about forming a COVID-19 response team. This will ensure that you are keeping on top with all the changes that are coming about from the province and the public health with respect to different health and safety protocols that you keep in place. And without this, you really left your own devices where these updates are not effectively being relayed to you, and then you find yourself in not being compliant with the most up-to-date standards. And lastly, reviewing and updating your safety plan. You need to ensure that your safety plan is regularly updated and it accounts for the current health and safety guidance and complies with any new requirements. And having a COVID-19 team will ensure that the safety plan is updated regularly. I'm going to quickly talk about the updated workplace layout and design. I'm cognizant of time. So with respect to the updated workplace layout and design, you can think about creating walk traffic flow that discourages congestion so that you have only one-way traffic going one ways and people are not rubbing shoulders walking in the office. Increase each employee's personal space by ensuring workstations are 6 feet or more apart, creating walls and barriers, discouraging spread of air particles, and updating your air filtration systems. And another important aspect that you need to keep in mind with respect to hybrid model is employee expectations with respect to behavioral changes. When returning to work, it is important that employers create updated expectations with respect to behaviors of the employees. And one of the things is according to the easiest way is creating expectations for hand washing. Encourage employees to wash their hands often and consider creating policies to reinforce the behavior. Next is banning or discouraging shaking of hands. And then adjusting meeting practices. Encourage your employees to limit participants at the meetings or put in place protocols where you don't have more than a certain set of people attending in a work meeting at the same time. Advise them to spread out and avoid shared multi-touch devices. And lastly, restricting unnecessary business travel. Reducing travel can reduce the risk of COVID-19 being transmitted, and defining what types of business travel are accepted. And finally, updating your cleaning practices. You need to evaluate and update ongoing cleaning practices to ensure that COVID-19 isn't lingering in the air or on the surfaces. Increasing frequency of cleaning routines and ensuring routines include multi-touch service and devices, increasing access of cleaning supplies to employees such as hand sanitizers, sanitizer wipes, and more. So this brings us to the end of the segment on the best practices for hybrid workplaces. I am now going to turn it over to my colleague, Cristina, who will talk about the ongoing and evolving cybersecurity risks and privacy risks. Over to you, Cristina.
Thanks, Shefali. So we're going to switch gears now and discuss ongoing and evolving cybersecurity and privacy breaches that employers should be aware of in hybrid workplaces. So with the advancement of technology and the increased sophistication of cyber attacks and fraudulent schemes, concerns grow about how employers can protect themselves against cybersecurity and privacy breaches. Organizations should be aware of the risks that are present and be prepared to address and resolve any potential breaches which may occur. So this slide has a few risks presented by a hybrid workplace environment. These include lost or stolen devices with confidential information. Organizations should consider the safeguards they have in place or which should be put in place to protect confidential information when devices are lost or stolen. The next two are tied together: devices less protected by internal corporate security measures and the use of unsecured Wi-Fi connections that are more susceptible to attack, as employees may be using their personal devices to log in remotely to work or to conduct business. And these devices may not have as stringent security as corporate devices do. Alternatively, employees may be logging on from unsecured Wi-Fi connections, which are either public or do not have firewalls as strong as that in the office. And organizations should consider how to deal with this risk. And as well, employees should be made aware of the best practices on how to protect confidential information on their devices and to ensure that their Wi-Fi connections are as secure as possible. As well, finally, difficulties in implementing existing financial controls to prevent fraud. When employees are working from the office, it is easier to implement financial controls as well as to ensure that they are followed. A hybrid environment where employees may be relying more on written communications as opposed to verbal ones presents added challenges. In order to mitigate the risks and repercussions of potential cybersecurity and privacy breaches, employers should keep in mind best practices related to the collection, use, and disclosure of personal information, and bear in mind the applicable legislation that provides what steps to take in the event that there is a privacy breach. So Alberta, British Columbia, and Quebec have their own privacy legislation, but Ontario does not. So the Federal Personal Information Protection and Electronic Documents Act, or PIPEDA, applies to personal information held by private sector organizations that conduct business in Ontario. Organizations handling personal information that crosses provincial or national borders are also subject to PIPEDA, regardless of the province in which they are based. PIPEDA applies to the collection, use, and disclosure of personal information in the course of commercial activity, which is defined as any particular transaction, act, or conduct, or any regular course of conduct that is of a commercial character, including the selling, bartering, or leasing of a donor, membership, or other fundraising lists. So personal information includes some of the following information: age, name, income, ethnic origin or blood type, opinions, evaluations, comments, employee files, credit records, loan records, medical records, evidence of a dispute between a consumer and a merchant, and intentions. What PIPEDA does not apply to is business contact information, which includes an employee's name, title, business address, telephone number, or email addresses collected, used, or disclosed solely for the purpose of communicating in relation to that person's employment or profession. PIPEDA also does not apply to an organization's collection, use, or disclosure of personal information solely for journalistic, artistic, or literary purposes. So PIPEDA also sets out 10 fair information principles. I'm conscious of time, so I will only focus on 3 of them. So one of those principles is consent. Knowledge and consent of the individual are required for the collection, use, or disclosure of personal information, except where inappropriate. This principle therefore requires knowledge and consent, meaning that organizations must make reasonable efforts to ensure individuals are advised of the purposes for which information will be used. Next, there's the principle of safeguards. Personal information must be protected by appropriate security relative to the sensitivity of the information. PIPEDA states that security safeguards shall protect personal information against loss or theft, as well as unauthorized access, disclosure, copying, use, or modification. Methods of protection should include physical measures, organizational measures, and technological measures. And PIPEDA also states that organizations should make their employees aware of the importance of maintaining the confidentiality of personal information. The third principle is individual access. Upon request, an individual must be informed of the existence, use, and disclosure of their personal information and be given access to that information. An individual shall be able to challenge the accuracy and completeness of the information and have it amended as appropriate. Where there are breaches that occur, PIPEDA sets out certain processes and procedures that organizations and individuals must comply with. So organizations must have monitoring systems in place in order to determine whether breaches have occurred. And they also have an obligation to report a breach of security safeguards involving personal information to the Privacy Commissioner, as well as to the individual whose personal information has been breached. The regulations of PIPEDA set out the content and the form of notifications required by PIPEDA, and records of security breaches must be maintained for 24 months after the organization has determined that a breach has occurred. So where it is found that a organization has not complied with PIPEDA, there are a few repercussions for that, such as complaints brought against organizations, either initiated by an individual or the Privacy Commissioner. Following the complaint, the Commissioner must prepare a report setting out their findings and recommendations, and the complainant may apply to the court for a hearing with respect to the complaint. Additionally, the Commissioner may enter into a compliance agreement with the organization, perform audits of personal information management practices of an organization, and where the Commissioner determines it is in the public interest, they may make public certain information that comes to their knowledge. Finally, organizations that knowingly contravene certain provisions of the Act are guilty of offenses, either punishable on summary conviction and liable to a fine not exceeding $10,000, or an indictable offense and liable to a fine not exceeding $10,000.